Okay, I went back and corrected some of my errors and fixed tweaked some things on a new system I had to get so I could do these videos. So just to bring everybody back up to where I left off. So we have the scales of justice, BC and AD. Zero balance. Now, you've gone back, you've done some reviewing, and you've read what the definition of red, you got a dictionary, and you've taken the red pill. Because that's what we're looking for. You're looking for your freedom. So we want to go back and correct our errors. So again, keeping the scales of justice balanced, you're going back. You want an estoppel. So we're correcting errors. For forgiveness. And we want an estoppel. And we do that by correcting our errors. Right, so we have both sides of the scales of justice balanced. So we're correcting our errors, right? So we can get our freedom. Now, looking backwards, because you're writing and you're looking backwards now because it's an event that's going to happen. So you write, and when you get up there, that's where your 0 point, zero balance on your accounts. So the estoppel, correcting errors, D, discharge, court documents. So you need to produce a court document in the form of an affidavit. Now, in commerce, the laws of commerce, all are worthy of hire. The truth shall remain supreme in commerce, and the truth shall be in the form of an affidavit. So we have to go back and correct our errors, and we need a form. So you're balancing both sides of the scales of justice. Now, if you go online, now I went online yesterday and I checked the BC Provincial Court form rules, and you'll find a form on highway traffic, and it's a fairly simple form. It's not complicated. You just write your name, your driver's license number, and at the bottom there's certain areas you fill out, and what you want to do is put the right words in there so you can beat your adversary to the guilty plea. So you want to strike the pleadings. So when you get in court, you have it documented that you're striking the pleadings. So you file an application as the defendant. Gives you A. Now you're A. Now you're the applicant. Now you're not the defendant, you're an applicant. And then you can file a notice of application of the law. And after you file your notice of application, you have to fill it out, and then you have the legal basis and the grounds. So you're on the grounds that the Law and Equity Act is the law in British Columbia, and then you bring in statutes. Now, if you want to prepare yourself ahead of time, like you're not producing anything quite as thick as this. What I want to get you a visualization of see how this is all tabbed. Now, in the tabs, you can do these ahead of time. And you want to print out the Law and Equity Act. So you have all the copies of the Law and Equity Act you're going to need. And that's the biggest amount of printing you're going to have to do. It's a fairly large act, but then you actually have a copy. You can show your friends. This is really important. Then the laws of England, because that's what you want. Section 2 and 3 of the Law and Equity Act, all English laws are still in effect in British Columbia. Which laws Statutes of Westminster, the first, 1275. 2 pages. It's not hard. Print out. Second one, Confirmation of the Charter, 1297. Tab that off. The Magna Carta, and that's where you want to get to, is the Magna Carta. Down here, these are the rights that you want read. Then we have liberty of the subject, 1354. The Justice of the Peace Act. Now you're going in, you want to deed your court, so you're going to empower the court to have a real judge in court, so you have the Justice of the Peace Act. Observance of due process of law. You have to have an original writ, and that's what you're doing. You're making an original writ. You write it, it's an original writ. I didn't write it, your lawyer didn't write it, the judge didn't write it, it's an original. Nobody else but you wrote it, it's your writ. Now I use the Confession of Ratification Act, but this is for a different document. And then you can tab them up, or you can use 3-ring binders. The courts allow you to use a 3-ring binder. Now, this is a copy of my petition. Now I'm going to take the camera so you get a little better closer look at this. Now, here, I'll use the other one. I do have 2 copies. Now you see the stamp there, received, as the date, and Vancouver Law Courts. Now this is the style of the proceedings in the Supreme Court in the review of the Judicial Procedure Act, the Act number, and brought under Class Proceeding Act. My name, Her Majesty Queen Elizabeth, in right of the Province of British Columbia. Record of the petitioner representing myself, the address I used for the courthouse, the date of the hearings. Now, inside, again, every time you do something, you have to redo your style. So again, here we go through, you can see, and this is the petition record and the tab numbers. I have 5 or 6 tabs on this. So I have my petition, the response, notice of application, application response, notice to admit, notice of intention to proceed. Those are all the notices that I used in this. And here's a copy of the petition. So, the petition to the court, how it was set up, proceedings, what the rules are. So I should go back and see Supreme Court Civil Rules, address of the registry, address for service of the petitioner, claims of the petitioner. I put my claims down, 2 pages. The order sought. Now, you don't go to church to pray, you go to court to pray. So I had a prayer and order, prayer and aid. Petitioner humbly prays for, and it was a court order. Authorizing, permitting the petitioner to file with this court an order for indigenous status. And then I went through all the different orders that I wanted the court to go through. And materials to be relied on. Factual basis. The legal basis. Truth in lending regulations. and then a response to the petition. This is important. These were what I needed to, information I needed to get for people. Just to let you have a quick read why they denied my petition. Let's go back. Let me double check something here. Oh. And then I was given a notice of application, and this is what you want to file. It's the notice of application. Now that's where you put the laws on. So part 1 would be the order sought, and this is what I was trying to show you. See, the whole petition, they say the whole petition be struck on the grounds that discloses no reasonable claim, is unnecessary, scandalous, frivolous, and vexatious. Pardon me. And is embarrassment and otherwise the due process of the court. Now, that's what you're really looking to do. Then the factual basis of why it should be, you know, why you went in. Response. Now, this is important. Supreme Court civil rules, right? That's how you enact the court. And the court cases that the Crown Counsel relied on: Hunt, Carney, Dempsey, Stevens. Now, these are important strata plan. These are really important court cases. And on the grounds, rule number 9.5, the Supreme Court Civil Rules provides the authority to strike out and dismiss a petition if, and it's petition or document. If you actually, you know, when you go and look at the rules of court, so you know what the whole rule says, because they didn't need to put the whole rule in. It discloses no reasonable claim, is an unnecessary, scandalous, frivolous, vexatious, is an embarrassment, or is an abuse of process to the court. And then B, Stevens, the test for a claim should be struck assuming that the facts stated in the statement of claim can be proved. It's plain and obvious that the plaintiff discloses no reasonable cause of action. And then again, Stevens, whether the claim is an embarrassment is established when pleading so confusing that it's difficult to understand being pleaded, or so irrelevant that is will involve parties to useless expense. Now, just hang on, I'm going to put my camera up here. I want to stop at Stevens for a second and show you. This is the defendant's copy. So this is really what you want to produce, because this is what I was, I needed to get something to show you what the defendant needs. So you want to have, this is basically how you want to have it look, tabbed up. And it sent highlights the photocopy of the rules and highlighted the rules for me. Now, they actually have the court cases printed out, so you can actually go back through the whole court case. The legal test, striking pleadings. So you can do a search on these terms to find out the cases relating to what, striking pleadings, this or that. Now, Stevens, and I'll go into my copy, my response, application response. And I went and did a little extra research on Rule 9.5, striking pleadings. The Supreme Court of Canada recently addressed this legal framework for striking pleadings pursuant to Rule 9.5. In short, the court repeated the long-standing test that pleadings will only be dismissed under BC Supreme Court rules if they have no reasonable prospects of success, and that the parties cannot tender evidence in support of these applications. Now, when you go into court, all you have is a ticket. Now, you have not been issued any proper court forms. So when you get into court and you beat your adversary to the clerk of the court, who's actually a notary public, you get a reliable witness signature before you get into court. Now, you don't have to get by the guilty plea to get the signature of the judge. You know, the documents are coming in. There's no argument. The judge can look at it, read it. The prosecutor's got a copy, and this is how you have to look at this. Let me go back here for a second again. Now, again, separation of church and state. So you have the legislature, the courts, and the feds. Courts in the middle. Now, when you're going to court, it's the Federal Crown Council taking you to court, not Provincial Crown Council. So it's Her Majesty's Queen Elizabeth in the right of Canada. So that's how you want to set up your style. It's Her Majesty Queen Elizabeth in the right of Canada. Now, when you write your name, it's your name in the right of the province of British Columbia. So it supersedes your writing. You can write in the legislature. In the province of British Columbia, you can write first, speak first, and then when you get to court, it all can be done. The independence of the judiciary. It's been, you know, you got something to write, read, okay, now we can speak about it. Changing the order of things so it can be done properly, so you can visualize. You really work backwards in court. You know, why in court? I don't know, not till you tell me why I'm in court. Now I got it in writing, now I can see. And your adversary has to travel, has to get in a boat from Ottawa, go around the Horn, come up river, dock to the dock, and you beat him to the dock. You walk down to the dock and you beat him from Ottawa because it takes 3 days to get here. So you get down, you get all your paperwork done, and you send it to your adversary, and then he's got to come in and get it signed. And you use the Age of Majority Act. You're the person. It says person, so it doesn't matter. You're the person named in the birth certificate. The funds being held in court belong to you, so you have that tabbed off in your application as material to be relied on will be notice of the age of majority, plus the notice of application are your materials in support, plus all the statutes that you write out as you write it out, you know, in support and the legal basis. So you can kind of set this all up so you can go through it. You know, when you look at the forms, and you don't see, this is something you don't get to see what these forms look like. You know, nobody's seen this. So if you haven't seen it, you know, it's hard to visualize something that nobody's ever seen. So I'm just going to take the camera and give you a little closer detail. See, so it's like, here's the registry number. So you go down, you get your doc number, and you write it up there. This is the cover page. In the Supreme Court of British Columbia, right? And then you have the line, Defendants, Book of Authorities. What the authority, you know, what court cases, balanced. Legislation, case review. Judicial Review Act. The court cases. And a strata plan. Now this strata plan Now, I'm just going to hold this so if you want to stop, you can write this down. This is a really important case for striking pleadings. Now they go in the background. You're actually only quoting a little piece of this. Maybe I'll find it in this one. My application. Sorry about this. Oh, pardon me. Sherman versus Gordon. Sherman versus Gordon, 2009, Cantel 71722, Ontario Supreme Court. Date 2009-12-16, docket number 06CV 310875 PD1. The court has been equally concerned where the court time has been sought and then squandered. The concept of proportionality has to be applied to the context of the litigant's use of court time as well as the expenditure of their funds. It is unfair to all users of the court where one party seeks far more court time than they should need because they are not prepared to do the work to streamline their motions. Court intervention should be reserved for situations where the parties are unable to resolve their differences inter se. If they extend to no effort in resolution but simply present the court with their problems, we will soon find we are unable to provide our services at a timely fashion. Wasting the court's valuable time. Time is money. You want your documents done ahead of time. They call your case, the judge looks at it, bingo, it's over. You're not wasting the court's time. They have not issued you proper paperwork. If you don't have a piece of paper issued with a court stamp on, why are you in court? You need to be in court. Now, you don't go to church to pray, you go to court to pray. So you need a prayer in aid. Now, when you're balancing the scales, you don't want to use a lot of paperwork. So if you Proverbs 1:11, that's good enough. Just to balance the scales. Just look at what that Proverbs 11:1. Now, if you take a Latin translation from the Vulgate for the state, for the state, for church, and then you have the English translation for the state. Now you've balanced both sides and the independence of the judiciary, and you go, you don't go to church to pray, you go to court to pray. And you have to rebut a lawyer's position. Now he's coming in with no reliable witness. He has no place to stand, and he has two soles on the bottom of his shoes. So you pray. So you want to start thinking, who's who? Now you're going into court, and you're not arguing anymore. You're staying in honor. You're putting everything in paperwork. Did you notice? Now you can take the next step. No. Go back and correct our errors. We can't go into court. It's what people want, courts. And we're down here, and you have full and complete access to the courts. Like I've had complete access to the courts in my life, and you have access to the courts. It's the out-of-court settlement, and everybody getting the real picture that, you know, you have provincial court, Supreme Court. You know, like sometimes you have to deal with these things. They go into Supreme Court, and no, it don't matter. You're being issued these papers. You know, somebody qualified has, you know, agreement among the people that somebody's got to go into court, and the Crown Proceeding Act is a writ in debt. We're indebted to somebody, has to go into court and deal with this. So we're indebted to them for doing it. Somebody has to do it, so we're indebted for them to make sure it's done right. And that's the Provincial Crown Council, not Federal Crown Council. Federal Crown Council, it's federal is in the bottom, you know, they float in. It's unfortunate that you know, people don't see the difference between the Federal Crown Council and Provincial Crown Council, because they're two completely different identities. Who you're coming in? I mean, you know, that's a foreign jurisdiction coming into provincial court, stepping in your territory. You know, it's like now we got to put a stop to about who's who. You know, the RCMP are federal employees. Provincial rights. You know, state your rights. You know, you got to state your rights. Where do you stand? You know, who's who? No, I'm here. You know, I'm here with the Aboriginal people. You know, although I have a speech impediment, I can only speak English. They're nice enough to speak to me in English, and we speak the same language. Always have. When I worked in the territories, and I've been dealing with the Aboriginal people my whole life. I've always been impressed at their ability to communicate amongst themselves about speakers. When they speak after the Berger report, when the Aboriginal speakers were commenting on the Berger report, it was really informative. How well they communicated with their neighbors. You know, they speak. You know, they speak to everybody, and then they speak. And we don't do that. We can't speak to an elder. You know, there are other people that can speak to the elders, but you know, you don't know about it. Doesn't pay to advertise. You know, it's there's a big conflict right now with what's going on. There's a hunger strike in Ontario with one of the Aboriginal chiefs on a hunger strike. It's unacceptable. It's like, no, over. They're free. Just because, we don't need anything around where you're living, we can ignore you. No, you don't ignore. The Assembly of Chiefs of the First Nations, we have to give them the respect they deserve. They're the elected chiefs, yes. And you have hereditary chiefs in the background. You know, you need to think, you know, people think, you know, no, you know, these are highly intelligent men that they can't quite communicate to a person. You know, you're talking to about a chair. You know, they know. That's the problem. You know, the Aboriginal people really actually know about commerce. They don't understand it. You know, it's like, you people are crazy. White men speak with forked tongue. And it's true. You know, you entitle yourself to speak. You know, you're not. That's not you. You're not Her Majesty Queen Elizabeth. Show me in writing that you can speak for Her Majesty Queen Elizabeth. Otherwise, no. You know, I can read what Her Majesty Queen Elizabeth said that you have to do. You know, it's a whole different thing when, you know, like, I'm reading about what you need to do. Nothing to do with me, it's you. So, to go back to preparing documents, because that's what this was about. So you have your prayer and aid, and you balance that out. And then your factual basis. So I'm going to go back to the application response again, or notice of application. Now, orders to be sought is striking the pleadings. Now, in order to do that, you want to empower the court. And to do that, what you do relying on the following authorities. 1. The Supreme Court Civil Rules, BC Regulations 168/209, Rule 95, and Rule 25. The inherent jurisdiction of the Superior Court of British Columbia. Now that, when you put that in writing, that supersedes, which court is the superior? The Court of British Columbia, right here. This is where we get our freedom, like the inherent jurisdiction. Okay, we already covered that. The common law authorities, and then you list the court cases. Those are the common law authorities that you're quoting. Now, you can use 2 or 3, and that's all you really need. Now, I'm just going to pop in here and get a document. I quickly did up just some of the court cases that I find will be extremely helpful. R versus Radley. Now, bringing in the Magna Carta, and R verse, and it's R-A-H-E-Y. To none we will sell, to none we will deny right or justice. As LaForest J. put it, the right to a speedy trial has been known to the common law for more than 750 years. And that was a court case in 1987. 1 SCR 558 at page 636, DLR 418.10. And then there's Valentine versus the Queen and the judicial independence. The judicial independence involves both the individual and the institutional relationship. The individual independence of a judge as reflected as such manners and security of tender, and the institutional independence of the court or tribunal over which or she presides as reflected in its institutional or administrative relationships to the executive and legislative branches of government. He concluded that judicial independence is a status or relationship resting on objective conditions or guarantees, as well as state of mind and attitude in the actual exercise of judicial functions. Judicial independence requires that the relations between judiciary and other branches of government do not impinge on essential authority and function of the court. The authorities and the general principles of judicial independence have been summarized by this court in Valentine v. Queen, and Beauregard v. Canada clearly established that a judge of the Supreme Court hearing a civil case would not have the power to compel another judge to testify as to how, why that judge arrived at his or her conclusions. That is the matter of privilege going to judicial impartiality in adjudication and the role of the arbitrator and protector of the Constitution. Similarly, one judge cannot compel another to testify as to why a particular judge sat on a particular case. That matter goes to an administrative or institutional aspect of judicial independence. The court must control administrative matters related to the adjudication without interference from the legislature or the executive. To allow the executive a role in selecting what judges hear or what cases to inquire after the fact would constitute an unacceptable interference with the independence of the judiciary. The requirements of Section 4 of the Public Inquiries Act are not met. Now, that will separate, the court, the independence of the court. You've acknowledged it. You get your rulings. Now the legislature and the executive can't come in and start going, no. We're all on the same boat here now. The judge, now we're speaking. the same language. At the end of the trial, you're free to talk to a trial judge. Trial's over. You're free to go. You struck the pleadings. You did everything in honor, and you can walk out in honor. So I'll let you go for now.